with you. Just say you will.
Hi guys, welcome to the channel. Please don't forget to hit that like button and subscribe if you haven't already. So I have a couple updates for you guys. In Destiny Payton'S appeal, she decided to file against her ex-husband LeBerick Williams. And I also have another update in the custody case involving Miss Melody Cherie and Martell Holt. So you guys, the last update I gave you guys a couple days ago where I notified you that Destiny was now filing an appeal to the case where she was found guilty of 9 counts of contempt for violating her divorce decree with her ex-husband LeBerick Williams. Now, Destiny has since filed a docketing statement as well as a amended notice of appeal. We're going to take a look at that. The documents will be on the screen. So this document is the docketing statement, and it was electronically filed today, January 29th, 2025. This is a pretty straightforward document. We see it says that the party filing the appeal is Destiny L. Williams, and it states the party that is being appealed against is LeBerick Williams. The jurisdiction, they have the box D checked for domestic relations. And down here, number 2 is checked yes when it says, is the order or judgment appealed from a final judgment? So that's checked yes. The date of the filing was September 13th, 2024. And that was Destiny's motion to alter, vacate, or amend the judgment where she was found and ordered to pay around $20,000. It says the date of the deposition was November 26th, 2024. So on the next document, and it says right here in the box next to the highlighted area, briefly summarize the issues on appeal. This information is for case processing and statistical purposes only. So then they go on to say, whether the trial court erred by holding appellant in criminal contempt for violations of a final judgment of divorce where 1, the appellant's conduct did not violate the unambiguous terms of the final judgment. 2, certain expenses that appellant was held in contempt for failing to pay had been held in abeyance by the trial court or were not allocated to appellant by the final judgment of divorce. Number 3, appellant was held in contempt for conduct protected by the First Amendment. And number 4, appellant was held in contempt prior to the trial court hearing her petition for rule nisi and modification, filed under, and it has the case number, which contains claims that would directly credit against or abate the cost appellant has been ordered to pay. So it seems under those bases are what Destiny is filing the appeal for. And down in the next box, it says, without argument, briefly summarize the facts to inform the court of the nature of the case. This information is for case processing and statistical purposes only. And Destiny's lawyers go on to say appellant and appellee were divorced on June 4th, 2024, which we know that is an error. Destiny and her husband were divorced way before last year. So we can look to that being corrected. And it says on August 9th, 2023, appellee filed a petition for contempt, alleging that appellant had violated the final judgment of divorce by discussing appellee on certain television shows and web series, failing to pay certain expenses, and interfering with the sale of the marital residence, among other things. And then down below, they're asking, do they think they need a settlement conference? And then Destiny's attorney said, it says, appellant does not believe a settlement conference would be beneficial. So you guys, we got to see a little bit explained more in the docketing statement, and it seems that Destiny did list off the reasons that she is appealing that case. So we'll keep an eye out, and I'll update you guys as they become available. Next, we're going to go over Mel and Martell's update. So the document will be on the screen, and it was electronically filed on January 27th, 2025. Now, where we left off was DHR was requesting for the motion to be quashed, or in the alternative for the courts to issue a protective order when it came to the records they had regarding the family. Now, this is the order on that motion, and it is titled order on motion to quash subpoena, or in the alternative, motion for protective order. And it says this cause is before the court on the motion to quash subpoena, or in the alternative, motion for protective order filed on behalf of the Madison County Department of Human Resources, hereinafter the department. Upon consideration of the same, it is ordered, adjudged, and decreed as follows. Item 1. The department shall deliver all subpoena records to the court for an in-camera inspection within 7 days from the date of this order. Item 2. The court would designate and make available to the requesting party those portions, if any, of the records which are material and relevant to the issues in this cause. Item 3. The department shall be allowed to substitute photocopies of those portions of records found by the court to be relevant and material to the issues in this cause. Item 4. The parties and their counsel shall maintain confidentiality of all of the department's records. Item 5. The parties and their counsel shall not disclose the department's records to any person or entity except A, the court, B, a party, C, counsel for a party, D, persons with prior legal access to the records, E, court officials involved in litigation, including court reporters, F, persons noticed for depositions or designated as trial witnesses to the extent reasonably necessary for them to prepare to testify, provide such persons are directed to keep confidential those records protected by the order of the court. And G, outside counsels or experts retained for the purpose of assisting counsel in the litigation or in anticipation as such, provided said persons are directed to keep confidential those records protected by this order. Item 6. Any record of the department admitted into evidence or otherwise made a part of the record in this cause shall be placed under a seal and shall not be made a part of the public record of this case. Item 7. The party which required production of the department's record shall pay the department the cost of providing a copy of the designated record, done this 27th day of January 2025, and it is signed, you guys. So that is the order on the DHR records. So the next document in Mel's case, you guys, it seems that Melody has had to file another motion to continue, and it was electronically filed on January 27th, 2025, and it states motion to continue. Comes now, the plaintiff Melody S. Rogers, by and through undersigned counsel, and files a motion to continue the trial set for April 15th, 2025 at 9 a.m. and as ground states as follows. Number 1, the plaintiff filed a motion to continue on January 23rd, 2025. Number 2, there was a scrivener's error in said motion as the defendant's criminal case is set for May 5th, 2025, not March 5th, 2025. And it says number 3, the deposition of the criminal case is necessary before the parties can move forward in this matter. Number 4, that no party in the above styled case action will be unduly prejudiced by a brief continuance in this matter. Number 5, the motion is not interposed for reasons of delay, harassment, or vexation, respectfully submitted by Mel's attorney. So you guys, they're letting them know that the date in their last motion to continue, where they were citing the criminal trial that is due to take place for Martell Holt, it was the wrong date. So they've had to again ask the court to push this case back until after that case is being heard. So the next document will be the order issued by the judge, and the document is on the screen. This document was electronically filed on January 28th, 2025, and it reads, order. Motion to continue filed by Holt Melody Cherie is hereby granted. This matter is hereby reset for a specially set trial on the 16th day of June, 2025 at 9 a.m. in the courtroom of the Madison County Courthouse, Huntsville, Alabama. Done this 28th day of January 2025. You guys don't forget to like the video. Let me know what y'all think down below in the comments, and I'll see you guys in the next one. Bye.